Brown LLC really does fight for people's rights and fights for the taxpayers. And this week, in October 2024, one of the largest settlements of the year, if not this largest settlement of the year, has become public with a $950 million settlement against RTX Corporation, formerly known as Raytheon, where Brown LLC had the honor and privilege of representing the courageous whistleblower who fought part of that battle. I'm here to talk about the different components of the settlement. I want to emphasize to everybody who's watching and listening that some of the conduct within are mere allegations, albeit there were some concessions made in its colloquy in the court in Boston and New York. But I will encourage you all to independently view the docket or give us a call if you have any particularized questions. Let me break down the settlement that led to $950 million. The first component, a $428 million False Claims Act settlement in which Brown LLC and our whistleblower is a signatory to that agreement. Amazing result, amazing courage of the whistleblower. If you understand the False Claims Act, you can understand that whistleblowers under that act are entitled to up to 30% of what the government recovers as a whistleblower award. Further stated, it's delineated based upon the information attributable to that relator. So the actual numbers I'm not disclosing here, but suffice to say, our relator, who we have the honor and privilege of working with, is walking away in pretty good shape for doing the right thing at the right time. The False Claims Act allegations in the RTX case stemmed around when Raytheon received contracts for Patriot missiles. And a lot of times in the defense contracting space, these contracts go as no-bid contracts. Seems kind of interesting, but the government gives a lot of faith into these companies to do the right thing. And you can see, if they don't do the right thing, not only can the taxpayers be harmed, but it also can weaken national security and harm the readiness of our forces and our missiles. Going back to the $428 million settlement, when companies are given no-bid contracts, there's something that's called TINA that's in play. TINA is an abbreviation for the Truth in Negotiations Act. And the federal government allows the companies to, of course, claim a profit. They are for-profit companies. You want to incentivize those companies to be able to build good machinery and good weaponry for the U.S. government, and good, when I say weaponry, defensive weaponry, we'll call it, for the U.S. government. But in order to do so, you have to build in a profit. So what the country does is enables the company, such as Raytheon, to honestly state its costs and have a profit a certain percentage above its costs. Simple enough, fair enough, as long as everybody's on the same page. What do people wind up thinking in these circumstances? They start thinking if they can inflate their costs, then they receive more money. And allegedly, that's what occurred in these instances. For example, if the company said that their costs for the contract were $100 million, when in fact they're $80 million, and they're entitled to 10% profit, since there's a $20 million differential in those circumstances, then they get an extra $2 million every time they overstate. Maybe my math's off. Maybe I'm not a math magician, but what I can tell you is all these numbers added up to $950 million, and we'll get into that in the aggregate in a moment. So you can see, if you accurately state the costs and build in a profit, that's fair. If you inflate the costs and receive a profit over the inflated costs, that's unfair. That's illegal. There may be criminal implications to conduct along those lines, as well as civil penalties up to triple damages under things like the False Claims Act. A companion concept to TINA and defense contractor fraud, although not present in the instant case, is cross-charging schemes, where oftentimes when a company depletes the amount that they can bill into a particular government contract, if it has multiple government contracts open, it will then bill into a different contract inappropriately. So for example, if the entity has a $100 million allocation for billing into contract number 1 and it exceeded that cap, and contract number 2 is coming in light, they start billing to contract number 2, which is just outright legal. There was a big settlement along those lines for cross-charging schemes, which is also fraud under the False Claims Act. Going back to the $428 million settlement, terrific work as well, not just from our relator, not just from our team here at Brown LLC, but by the government. Art Coulter, senior trial attorney, wonderful job. Jared Weisner, trial attorney, wonderful job. Brian Lamacchia, the assistant United States attorney in Boston who handled file, terrific. A lot of these cases flourish or languish depending upon the industriousness and the hardworking team assembled at the Department of Justice. Here, we had pretty close to a dream team who worked the case pretty vigilantly, hard, was in constant contact, and effortlessly, and I won't say effortlessly because there's a heck of a lot of effort, but anytime we need to get a hold of them and vice versa, it seemed to have worked, which resulted in this fantastic result. I read in the press that this may be heralded as maybe the second biggest settlement along these lines of all time. Once again, amazing work by the firm and tremendous courage by our insider relator. She came forward at the right time. She did the right thing. And as a result, corporation is now held accountable and she's rewarded for what she has done. The second component of the settlement is $252 million for a bribery scheme. Now, this is interesting because conceptually, how you address a bribery scheme has to do with something called the FCPA, Foreign Corrupt Practices Act, when you bribe a foreign official. And individuals at Raytheon allegedly bribed a foreign official in order to induce business. Now, whether or not that's squarely covered under the False Claims Act is generally really arguable. A lot of times it's not. But if it's a publicly traded company, it certainly can be addressed through the SEC whistleblower program by properly filing a TCR. Now, oftentimes, what happens is you'll see something like that happen in court, where in a federal court in Manhattan, they announce the result the same day for the aggregate of the $950 million about the bribery allegations. And what you generally see is a month or two afterwards, something called a notice of covered action in the SEC portal. Will we see that in the next month or two? Time will only tell. What whistleblowers, if any, will receive credit for that? Time will only tell. What I can tell you is the SEC program is cloaked in anonymity. So you could potentially file something into the SEC program and stay anonymous from start to finish with an SEC whistleblower attorney. But with the FCPA, Foreign Corrupt Practices Act, sometimes you could address it through the SEC whistleblower program if it involves a publicly traded company, sometimes through the False Claims Act, depending upon how directly it impacts the United States and its contracts. And in other times, potentially, this year was introduced a new DOJ whistleblower program that's meant to be a catch-all to address when there's a deficiency in the other programs. But that's really the key. If the other whistleblower programs are not available to address an FCPA or other violation, and it may constitute a criminal act, then potentially under the new DOJ program, you could recover as a whistleblower. Nobody has as of yet, but the program is in infancy. The shelf life of a whistleblower case can be several years. This instant RTX case, from our perspective, took several years, but of course was worth the wait. Now on to the third component. The third component of the settlement was a $147 million settlement attributable to ITAR and AECA. ITAR is the International Traffic in Arms Regulations, and AECA is the Arms Export Control Act. Both of those seek to limit the ability of a company to compromise sensitive information to the rest of the world. Loose lip sync chips, you want to keep things under control and under wraps. So for that portion of the resolution for Raytheon and RTX, Whether or not a whistleblower is covered by it would depend upon what program you can compartmentalize it into. As just indicated, with the new DOJ program, potentially a whistleblower stands to receive an award for that recovery. And anytime you have something that may be construed as criminal in nature, you want to examine to find out what program, if any, can cover it. Overall, these three settlement components aggregate to $950 million. We have a lot more to say in the coming weeks about this and the really remarkable achievement of the federal government on Relator. But for now, we still have certain things under wraps. But if you are aware of an analogous situation, particularly in the defense contractor space, please feel free to call Brown LLC at 877-561-0000 for a free confidential consultation. Past results don't guarantee future success, but as you can see, our law firm, which contains several former DOJ alumni, Department of Justice alumni, myself included, who was a special agent and legal advisor with the FBI, love working these types of cases. There is unfortunately no shortage of fraud against the federal government. What happens is people think the government isn't looking. In one sense, the government's everywhere, and in another sense, they ain't anywhere unless individuals from the inside have the courage to come forward and spill the beans. They're just too busy following everyone and everything to be able to figure out the individual scheme. And close to $1 billion may seem like a lot of money, but the way the government spends, that's not even a lot of money. So if you know of something and you want to tease out a fact pattern and need a free confidential consultation, call us. If not, please speak with a firm that focuses its practice on protecting whistleblowers like Brown LLC. But this is not the type of work that's suitable for every mom and pop shop. You really need an attorney and a law firm that's got a track record of success in this space. Once again, thanks everybody for their efforts, and I look forward to speaking with you during our next video.